All right. Good evening, everybody. Thank you so much for taking some time from your schedule to be here with me. I'm going to start the webinar. I know there are people that are still coming in. Initially, I'm just going to sort of tell you a little bit about what I'm going to talk about and then tell you a little bit about myself and our law firm. Um, I know people that are here. We had about, I think, 34 or 5 people that had registered. Usually people don't register for these sort of webinars just because they have nothing to do. They usually are here because there's something that has happened or they're concerned about, these sort of planning. So I'm hoping that today with what I have prepared, I can share some information with you, and hopefully it's helpful to you, and obviously it can be helpful to your family. So the title of the webinar is Don't Let Your Family Go to Probate Court Because You Failed to Have the Right Planning in Place. We're going to talk about probate. We're going to talk about different options as far as what sort of estate planning you could have. But before I get to that, let me tell you a couple of things. So during the webinar, I know sometimes people have questions. I noticed a couple of people have raised their hand. Um, I'm not sure how to answer that. But if you do have questions, please put them in the chat in the Q&A box. And what I'll do is I'm going to talk for about 40 minutes. I'm going to start my clock here too. So I'm going to talk for about 40 minutes and then leave about 20 minutes towards the end so that I can answer your questions. I won't take any questions as I'm going through the slides just because it'll just make it faster for me to go through the slides. But I will go back and answer them. Sometimes people say, I forget what I was going to ask. That's when you actually put it in the chat and you have your questions there. So you don't forget. It's there, and when I get to it, when I get done, I'll go through it and I'll ask me easy questions so I could answer them. We are recording this webinar, so after it's done, my team will go ahead and email it out to everybody that had registered for the webinar. It'll most likely be tomorrow or maybe Monday, or the day after that is a Saturday. But we'll get you the recording. If for some reason you're home and you're like, I gotta watch more of this estate planning webinar, you have it. You could watch it. I'll have a couple of polls that I'll sort of launch, and I'll want to get some participation from you just to kind of gauge the reason you're here. So then I know which areas I should maybe focus on more. And then what else? What else I could tell you? At the end of the webinar, I do have a section where I'll sort of tell you how you could make an appointment to meet with me to set up your family planning meeting. I will offer you a special sort of a discount. I kind of tell you how that works. What has happened is that we had a lot of people that have been excited to sort of meet with us and talk about their estate planning, and the discount that I will be able to offer. I could only offer it to the first 8 people that register to meet with me. And that's really just because that's the amount of time that I will have to be able to allocate to the people that are looking forward to meet with me. If for some reason it doesn't work out, you could register for next month or something like that. But obviously, if you want to get something done, then hopefully you're the top 8. What else? Let me ask you a couple questions. Let's what I wanted to find out is I wanted to find out what's the main reason you decided to join this webinar? Is it that you're looking to just get more information about estate planning, or you're at a stage that you're ready to sort of start your estate planning? So please take just a couple of seconds, answer this one. We have some people that I've already answered. I appreciate that. Thank you. Um, I'll leave it up for just a few more seconds, just so everybody gets a chance to put their answer in. I think we got 53% of the participants, 60% now that have answered. All right. Thank you. I appreciate your participation. Um, the other poll that I want to share with you and get you to sort of answer is I'll launch it. Let me tell you a little bit about myself. My name, as I've already stated, it's Ali Talai. I'm a trust and estate planning attorney. Our firm is here in Woodland Hills, California. What we focus on is just estate planning. We do, revocable living trust, wills. We do advanced estate tax planning, asset protection, trust administration, probate. We do set up business entities and sort of business succession planning and sort of how a business could be connected to the trust and those sort of things. Becoming a lawyer, this was actually the backup plan. Initially, I was in real estate and mortgage business, and then 2007 and 8 happened. Um, Decided that I needed something more sort of solid. So then I decided to go back to school. I went to night school from 2009 to 2013, and finally became a lawyer in 2014, and I've been practicing now for 10 years. As I started practicing estate planning, I started to realize that I really need to know more about tax law in order to be able to help my client, in a better way, more sufficiently, and comprehensively. So I went back to law school, got an advanced tax degree. They refer to it as LLM in taxation. So I am really an estate planning attorney and also a tax attorney. And it's been really helpful when I get to talk to the different clients that have been kind enough to work with us to really create a estate plan that takes care of the regular sort of estate planning needs and things that are required there, but also it has this tax planning in there, income tax planning, capital gains tax planning, particularly at the time a spouse passes away or at the time both spouse have passed away. I'll sort of mention, there are a few slides that I'll mention how that income tax planning will come into play. I do have 2 kids. I am married. My kids are 5 and 4. And the reality of it, when we do these sort of plannings, in most cases, we're doing them because we really love our family, we really love our kids. Because in most of these estate planning, we don't really get to see the actual result because they come into play at the time we've passed away. So it's really individuals that do these things and proactive and want to make sure they get these things done. They really like their family, they love their family, and they want to make sure they get it done. All right, so I found my other poll that I wanted to share with you. This other one. This is the one that I'm trying to figure out if you already have a state plan and you're looking to maybe review it or update it, or you don't have a state plan at all. I was reading something not too long ago, and they were saying about 1/3 of the people that live in the United States have a completed estate plan. And that really means, just having a trust sometimes is not enough. If you have a trust, you got to make sure your assets are tied into it. So it looks like, let's see, 57% of the participants have participated, and it looks like most of the people don't have a estate plan in place. So I guess this is a good place for you to be. Stick around, and we'll talk about it. All right. Thank you for letting me know. I know what to focus on more, so thank you so much. I appreciate that. All right, so let's start. What I want to do is I want to tell you the agenda for the meeting. I want to tell you what I will cover. I'm going to talk about the importance of estate planning. I'm going to talk to you about how and what the probate process is. We'll talk about the different options you have when we're talking about estate planning. We'll talk about the benefit of a revocable living trust. My favorite part, creating sub-trust for your children's inheritance trust for your children within your revocable living trust. And then we'll talk about other essential planning documents that are really important when you are putting a estate plan together. It's not just about the trust. It's not just about having a will, if that's the type of a plan we're going to do. There are other documents like the healthcare directives, HIPAA authorization, power of attorney, and similar documents like that, which I'll sort of go over as well. And then I'm going to tell you how you could do your schedule, how you could schedule a meeting with me. And lastly, we'll answer some questions. All right, so let's start. Importance of estate planning. There's a lot of times that I have conversations with clients and they tell me that they're not really worried about planning for incapacity, because if something happens to them, their spouse is going to be there and they'll sort of take care of what needs to be done. And that is absolutely very far away from the truth. The reality of it is the fact that you are married, and let's say your spouse has full capacity to do things, it does not mean he or she can actually do most of the stuff that could be required at the time one spouse become incapacitated. If there's a need to sell a home that you guys own jointly, if there needs to be a sort of a refresher or refinance of the loan that you have on the property, if there needs to be an access to a bank account, if there needs to be tax returns filed or signed, all those things require both spouses to sign, particularly if, let's say, if it's a real estate and it's under both names. Recently, to my surprise, Jay Leno was on the news. His wife, unfortunately, lost her capacity. Mental incapacity is key here. And, you know, you would think someone like Jay Leno made a lot of money while he was on TV, but unfortunately, he didn't do the planning that we're talking about today. So he had to go to court. So even though he was the spouse, he couldn't do most of the things that are essential, particularly with estate planning. And so he had to go to court and have the court appoint him as the conservator of for his wife, and so that he could do some proper estate planning. So one of the importance of estate planning is that we want to make sure we have proper incapacity planning in place. Then it's really now avoiding this probate nightmare. Probate is a legal process that allows assets to sort of pass along from one person to another, usually beneficiaries, usually kids. But it is just crazy. I mean, I guess if you don't like your kids, this is what you could do. You let them go to probate and kind of give them one last parting gift. But again, like I mentioned, I'm pretty sure if you're here taking an hour of your time at 7 o'clock on a Thursday afternoon, Thursday evening, that's not the case. And you actually like your kids, you have good kids. So we want to make sure we do something that we could avoid this whole probate. Probate is very expensive. It takes a very long time. And again, when we're talking about expenses, the more expensive something is in estate planning, it really just means there's going to be less left for your children and loved ones. So if we could do a plan, if we could put a plan together that avoids probate, we're going to have a better result as far as things getting done much faster and less expenses that would have to be paid. If you have minor kids, again, having a proper estate plan becomes absolutely important. The fact that if you don't have a proper a will that names legal guardians in there, that becomes important, because if something happens, both parents pass away, what you're actually doing, if we don't have proper planning in there, we don't have proper documents, you're allowing a judge who, you know, they're educated, they are, you know, they, you know, want the best for the families, all those things, they're great, but they still don't know you. They still don't know your family. So if you don't have, if you have minor children and you don't have proper guardianship paperwork, what you're really doing is that you're giving that decision up to someone who doesn't really know your family. So again, having proper estate planning in place when you have minor kids becomes really important. Something that you could do for, you know, for whatever, you know, however amount that it can result to, as far as eliminating or at least reducing family dispute, is having some sort of a document that clearly states what your intentions are, how assets are supposed to be divided, who's supposed to get what percentage they're supposed to get. That could really help to eliminate or at least lessen this family dispute. Every week I talk to a client and they tell me, you know, their parents passed away and all of a sudden everything got crazy and there's a huge family feud. So that's another reason why we want to have proper estate planning in place. I was going to move this slide. I totally forgot to move it so that Let me continue with the importance of estate planning, and then I'll go back and tell you about the other slide that I just went by. Unintended beneficiaries. Believe it or not, all of us have an estate plan sort of written for us. Every state, including California, has a set of laws that they're referred to as intestacy laws. And that really just says, hey, if the person doesn't write a will, doesn't write a trust, the government is going to sort of determine who is going to get what sort of assets, how are they going to get it. So again, if you don't want to, you want to opt out of the government sort of plan and do a more proper estate planning to sort of avoid probate and having capacity planning and all the stuff that I sort of talked to you about. Lastly, if you own a business, if you have an S corporation, you have a LLC, and you're sort of involved in this business, you run the business, you sort of pay the employees, deal with customers, with patients, with clients. If something happens to you and you're not there tomorrow, this business is not going to be able to run sufficiently, if at all. If employees are not able to get their paychecks, most likely they're not going to be continuing working for the business. If there are no employees, clients and customers are going to stop coming there, and that really all together will result into the value of the business sort of being lowered and lessened. And so having proper estate plan in place to so that if something happens to you, the business could continue and run as smoothly as possible becomes very important. All right, so let me go back up to the slide that I missed, or I had in the wrong place. I want to just briefly talk to you about what options do you have. You could do three main planning here. Option one, a lot of people that answer they have nothing in place. You do have something in place. You have this whole option of doing nothing. And as I mentioned, doing nothing, realistically, we're on the intestacy laws and the government sort of plan as far as how our state would be divided. The good thing about it is the cost to do this kind of a plan, upfront fee, zero. The way to do it is very fast. As I said, you already have it done. However, it may not have any cost up front, but all the costs are sort of in the back end of it, because if I have nothing and I have a home, if I have other real estate, if I have a business, the only way to have those assets transferred would be the process of going to the probate court. And I'll tell you how the cost is calculated and all that stuff. Probate takes a very long time. The cases that we have takes about 1.5 years, and it's very expensive. Option two is having a will. And sometimes having a will might be enough. It depends on the type of assets you have. If you have an insurance, you have, let's say, a life insurance, or you have your main assets are money in a bank account, then just those accounts allow you to indicate who the beneficiary is. So then you can use those provisions within those accounts to be able to pass the assets along to whoever you want to. And the will could be used to indicate where other personal properties are going to, cars and maybe other personal household sort of items. But if you own a home, if you own a business, then having a will still be fine as far as you having the ability to indicate who you want to get your assets. But it still means we got to go through probate. It still means the expenses and the delay and all the other stuff. The third option, which in most cases it would be the better option, is that you have a trust-based estate plan. And today, the main goal and the main topic is having a revocable living trust. Revocable living trusts are sort of the foundation of your estate plan. It doesn't matter if you have $1 million estate or $100 million estate. You still need a revocable living trust as your initial foundation, initial trust. If you are lucky and you have a larger estate, we do advanced estate tax planning for clients that have assets over 10, 20, 30 million dollars, and there's different sort of planning that is involved. But again, step one is we need a revocable living trust. We would add other trusts to the plan if the client has a larger estate. All right, so let's talk about understanding the probate process. As I mentioned, probate is a legal process that facilitates the transfer of assets owned by a deceased person. This person part is important to their heirs and beneficiaries at the time they've passed away, or sometimes we go to probate court at the time the person has doesn't have mental capacity. So I know most people that are here, I'm assuming everybody, but you've probably been involved in a real estate transaction where you sold your home, bought a property, or you knew of somebody that did this thing. But I'm assuming everybody probably has been in a real estate transaction. And I'll use this example. Let's say you're purchasing a property. In order to purchase this property, beside all the escrow documents and the purchase agreement and all the other stuff, the main document that transfers the property to you is a grant deed. This is the document that the seller signs. I know when you bought a home, you signed a lot of documents, but I can guarantee you, you did not sign a grant deed, because the grant deed is only signed by whoever is transferring the property. So if I am purchasing a home, whoever is selling it to me, he or she or they would sign this deed and transfer the property to me. It really doesn't matter if I'm purchasing this thing and paying money for it, or the grantor, the owner, is feeling very, happy that day and wants to just gift me the property. Usually parents gift properties to their children in a trust. A lot of times I hear parents saying, we're just going to gift the house to them. There's a lot of unwanted tax consequences. So again, mainly you would want to make sure whatever transfer you do, it's within the trust, particularly if it's going to be for your children. So the fact that there's money being exchanged or not being exchanged doesn't make a difference. Either way, whoever is making the transfer signs the deed. So now we have the same home. Let's say the parents wants to transfer it to their children, but now the parent has passed away, or parents have passed away. Whoever owned the property is not alive. We need the same thing. We still need a deed. We still need it to be signed, and that's the document that is used to transfer the deed in most cases, to transfer the property in most cases. So one of the first thing, and one of the essential things that a probate court does, when we file our probate cases, the first thing we're asking the court is that we want the court to appoint somebody that we have indicated who that person is. We want the court to allow them to be the executor, the administrator, or the personal representative. This is just meant to confuse us more. 3 names for the exact same position. So we'll just say the administrator. So here, what we're asking the court to do is that we want the court to appoint and give this person powers as an administrator. So after filing this thing, waiting 2 or 3 months, finally the court hears our case. They say, okay, we'll allow this person to be the administrator. Then we'll have to wait another month or so to get the documents back, get the certified documents back. And then that person could now sign the grant deed. The administrator will have power to be able to transfer the property to, let's say, if it's a sale transaction, to the buyer. If it's being transferred to the children, sign all the documents, sort of take care of everything. But as you could see, this just takes a long time just to kind of get to the first step to get the administrator appointed. The probate process, since we're in the court, we're sort of attached to the court schedule. And again, that's probably one of the main reason that it takes so long, because in most cases we file a case. We had a case today that I was in court. We had filed to be heard about 2.5 months ago. And today was finally the time that we got a chance to go in front of the judge. So usually it's all the delay is just kind of hurry up, do stuff, and then wait for a few months, and then same thing. So that's one of the reasons why it takes so long. The other issue with probate is that the cost that is associated with it, in most cases, is very high. And we don't have to die to actually calculate what the probate fee would be, because the fee is a statutory fee, which is based on a percentage of our gross estate. So let's say that same home was worth $1 million. The probate fee, the minimum statutory fee, is $46,000. It does not include the appraisal fee and inventory fee. It does not include the filing fee. It does not include the insurance, the bond fee that the court in most cases requires. And then, as you could see here in parentheses, I have gross estate. So if the same home that is worth $1 million, let's say there's an $800,000 mortgage on this property, it doesn't matter. The fee is still $46,000 because the fee is calculated on the gross value of the estate. So these are all the reason why we try to avoid probate. All right, let me tell you now when this whole revocable trust and how is it that a trust structure can all of a sudden magically get rid of the probate process. And the reason this happens, it's really a couple of reasons that this happens. One is that, well, in order to do this thing, we first need a trust, so then we create the trust. In a trust, you have three main roles. You have the person who creates the trust. In most cases, they refer to that person as the grantor. Sometimes they refer to the person as the trustor, trust maker, settlors, 4 different names for the person who is the creator of the trust. Then you have the trustee. This is the manager of a trust. In a probate setting, the manager had 3 different names, right? The personal representative, the administrator, or the executor. In a trust setting, luckily, they only have 1 name for that position. It's the trustee. But again, it really doesn't matter. You're really just working in the management section and, doing what the trust says, or, what needs to be done to administer the estate. And then you have this third position, the beneficiary. And if anybody asks you ever, if you have a trust, where should I name you? Ask them to name you as the beneficiary. That's the best position to be because you get to benefit from the trust and you don't have to do anything. But keep in mind that these trusts, we say beneficiaries, and a lot of times people, when I talk to them, they say, I want to name my kids as the beneficiary. But the reality of it is that these trusts have 2 types of beneficiary. They have a current beneficiary who is the beneficiary of the trust right now when the trust is made. And then we have future beneficiaries. In these revocable living trusts, when we're creating these trusts for you, you are the current beneficiary of the trust. When we name your kids or whoever you want to name as beneficiary of the trust, they are the future beneficiary. They're not the beneficiary right now. They have no rights in the trust. You can change whoever you put in here. They have no right within the trust. Sometimes people tell me, or parents tell me, I don't want to name my kids. What happens if they get a divorce? I don't want the spouse to try to come after our asset. It's not going to happen because when you name your kid, they have no ownership in the trust for any spouse or creditor to kind of reach in there. But anyway, so these are the main 3 roles in the trust. We create the trust. That's step 1. Step 2 is that we have to fund the trust. And by funding, what that really means is that we got to connect the assets that you have somehow to this trust. You could have the nicest looking trust, the best, trust with all the great provisions in there. But if the home that you own or the business that you own or the LLC that you have, if those assets are not transferred into the trust, it's still going to require some sort of a probate proceeding if something happens and you become incapacitated or pass away. So having the trust is step 1. Step 2 is we fund the trust. And then now we get to this place that the person who created the trust passes away. The fact that the person who created the trust passes away makes no difference in the validity of the trust. When the person who creates the trust passes away, the trust is still an active document. It does not cancel. It does not terminate because the person is not there. So that's really one of the main reasons that we don't need to do a probate, because first of all, the person who owned the property transferred the assets under the name of the trust. The person passed away, he or she doesn't have any asset under his name because they're all owned under the trust. The trust is alive. The trust didn't die, so it's still functioning. It has legal power to do what needs to be done. And lastly, the reason that we don't need to have the court give any powers to the trustee to act on behalf of the trust is that the trust automatically gives those powers to the trustee. so the trustee can function and transfer and do things that needs to be done from the second he or she becomes a trustee of the trust. So usually if we have a trust, we can avoid probate because everything is owned under the trust. And in most cases, the administration can be done much faster. I mean, we've done administration in less than a month versus waiting a year and a half. And again, there are some costs associated when we go through trust administration. It doesn't mean there's no cost associated with it, but it's not the same sort of expense that you would expect to have in a probate proceeding. So that's how we avoid probate, by having a proper estate plan in place, having the trust funded with the assets you have. And that's how we would avoid probate. If we avoid probate, the costs are not going to be there. You get some privacy because when we're in the probate proceeding, everything is public. All the information, anybody could go to court, find out what you had, who's getting it, if you had a will, what does your will say. But with a trust, we don't file. The trust does not get recorded. Everything is kept private. Something happens now, both spouses have passed away, the grantor, if it's just one person passed away, the administration, again, gets done privately. It's the attorney and whoever is the trustee. Really, those are the ones that are involved. And then sometimes the question I get from clients is that they ask, am I going to lose some control if I create a trust and transfer my assets in there? And the response to that is that no, absolutely not. You still have all the controls, everything that you could do before. We set them up in such a way that you don't even have to file a separate tax return for them. You would continue to file the same tax returns that you're filing now. All right, let's talk about creating subtrusts for children, inheritance trust. This is probably my favorite part of the meeting. I'm sort of skipping a section in the lifespan of the trust. You create it, you fund it, then it has incapacity planning. Then if it's a joint trust, when the first spouse dies, there's some planning in there, really important. And then at the time the second spouse dies, you get to this place in the trust that we're going to make distribution. We're going to say how the assets are being distributed. It really doesn't matter if we're saying, to one child, to my friend, to a charity. That distribution doesn't matter. As it concerns with this inheritance trust and subtrust. The percentage that you do doesn't matter. But in general, there's really two ways to do it. One way is that you say everything goes outright to the children. The distribution is outright. 50-50, 1/3, 1/3. If there's a home, the title of the property gets transferred to, Joe Smith, the name of the child. Hopefully that's your child. But it goes outright. That's one option. The other option, which I have here, this inheritance trust, what we're doing is that we're creating a trust, a subtrust for each beneficiary within your trust. It's there, when we create the trust, it sort of sits there for hopefully a very long time. At the time we pass away, this trust sort of springs into action. We usually get an EIN number for it. And now when we're going to make distribution for that particular beneficiary, the distribution, instead of going to his or her name personally, it'll go into this trust. And so usually the child is the beneficiary. They could become the manager, the trustee of their own trust at a certain age. The main difference is that if I own asset under my personal name, it doesn't matter if it's an inheritance. If there is a lawsuit filed against me, and I'm, found to be at fault, they get a judgment against me, they can attach the assets that they have left, I've gotten from my parents. I get in a car accident, bankruptcy, divorce, any of those sort of things. The creditor could attach my inheritance practically. The other option, in my opinion, the better option by having these inheritance trusts is that if now something happened, child gets in a car accident, there's some sort of lawsuit, some sort of divorce, the assets that are left in this trust are not going to be attached by the creditor, or at least it'll be very, very difficult for a creditor to be able to attach these assets. So it really provides them asset protection within the trust that you're creating. The first slide, the first bullet point here in divorce settlement, subtrust can protect the child's inheritance from being considered marital asset. And so that would safeguard the asset. Sometimes we had cases that the divorcing spouse said, you know what, you're right, that's your parents' asset. I'm not gonna, I don't want anything, but let's say this property or investment is making $50,000-$100,000 a year. I want the income that is being generated to be calculated as part of the child's income for child support or alimony. And again, with having the right planning in place, we could get rid of that. If there's lawsuit, we talked about that. Bankruptcy, we talked about. When we create these subtrusts, sometimes you have maybe a beneficiary who has a special need and they're receiving some sort of Medi-Cal or some sort of government assisted, they're on some sort of government assisted program. And so we could have a special needs trust built in there. So then if something happened, parents pass away, the assets goes into this special needs trust, the child can still qualify for whatever government help they were receiving. And at the time they pass away, Medi-Cal could not have a right of recovery. We can put these incentive provisions within these trusts for our kids. So if we're not around, we still could sort of incentivize them to do good, be better. And then lastly, so many people tell me, I love my son-in-law, I love my daughter-in-law, but if something happens to us, we want the inheritance to go to our kids. If something happened and our kid unfortunately passes away, we want the inheritance to go to our grandkids. We don't want anything to go to our, son-in-law, daughter-in-law. And so by having these subtrusts, we could control how the asset is being distributed. If the asset is just outright to the child, there is not a lot of control. If something happened, there's a divorce, something happened, a child passes away. So if we want to have a plan in place that provides family bloodline planning protection, that's definitely considering a subtrust, inheritance trust becomes really important. And then there's some income tax planning. I'm going to put on my tax attorney hat here. And there's a lot of income tax planning with these trusts that are created at the time the first spouse dies, at the time the second spouse dies, that usually when I talk to clients, they have no idea. And most of the attorneys that I know that do this kind of work, particularly because most attorneys are just estate planning attorney. And then if they're a tax attorney, they usually don't do any estate planning work. My sort of specialty of doing both really allows me to incorporate some of this income tax planning in the planning that we do for our clients. And I won't talk to you more about this thing. I could talk about this for a long time, and I know I'm running actually out of time. I got another 4 or 5 minutes for my 40 minutes. Let's talk about what happens at the time the first spouse passes away. Again, most people usually don't know what's happening at the time the first spouse passes away, at least within their trust. And again, this becomes really important. There are different options that you could have within this trust. At the time the first spouse dies, if you have a trust, if you look in there, I'm telling you, there is a section that discusses what is supposed to happen. Sometimes people tell me, Ali, I want to draft this trust and I want it to be in such a way that at the time one of us passes away, all the assets just goes to my spouse. She or he can do whatever they want to do. They can terminate the trust. They can change the beneficiary. They could, use all the funds. They all full control. And sometimes that's fine. We create a survivor's trust within this main trust. And that's what this survivor trust would allow the surviving spouse to do. He or she can practically do anything. And so it's ideal for a client that has been together, spouses that have been together for a very long time. They have children from the same marriage. Children are older. That's great for that kind of a family. However, and there's really not a whole lot of tax planning that we're trying to do either. However, you could see, if you're a younger family or if it's a blended family, this whole idea of the surviving spouse having the ability to do whatever he or she wants to do may not sit well with you. And so that's what I mean, that this whole planning at the time the first spouse passes away becomes really important, at least discussing it and sort of thinking it through. So there's really 3 different options that could be built into this trust at the time the first spouse dies. There's subtrust that gets created. You had the survivor's trust, you have this marital trust, sometimes they're referred to as a Q-tip trust, and then you have this other trust called a credit shelter trust or a bypass trust. I don't want to get you confused, but there are options there, and the intention and the reason they're there is that we want to figure out, do we want to give the surviving spouse all the powers and he or she can do anything, or do we want to set it up in a way that she still can use the assets, she still can manage the assets, she can keep her lifestyle, or he could keep his lifestyle, but the surviving spouse could not change the beneficiary to the portion of the asset that belonged to the spouse that passed away. Or we want to do some planning to provide some asset protection for the section or the portion of the spouse that passed away. Sometimes we were trying to do some estate tax planning. Let's say it's a wealthier family and we're a little concerned about estate tax planning. This credit shelter trust, sometimes referred to as a bypass trust, that would allow us to do some planning. So I just want you to know there are options there. And when you're working with me, we'll go through it and sort of discuss the different options. If you end up not working with me, it doesn't matter. Make sure whoever you are talking to, that you ask these questions and you're aware of what's happening and have them explain. If they cannot explain to you, I'm telling you, they probably don't know it that well. All right, so let's talk about the other essential documents. One of them, so you do the trust, but there's other documents that goes along with it. If we're doing a trust-based plan, we may just do a will for you. It really just depends on your asset. But we definitely want to make sure we have a financial durable power of attorney. You appoint someone to be the agent. It could be the spouse. It could be anybody else. And that person, if you become incapacitated, could make financial decisions and deal with the IRS, the bank, the real estate, all that stuff. Then you have your advanced healthcare directive and HIPAA authorization. These are two separate forms. Again, you specify who you want to be the agent, what sort of medical preferences you have. The advanced healthcare directive gives the agent the power to make medical decision on your behalf. The HIPAA authorization gives the agent the power to obtain information, medical information from your doctor, from the hospital, from the insurance company. It would be difficult to give the agent the power to make medical decision, but no power to get any medical information. So it's really essential that these two forms exist at the same time. We also do a pour-over will. We do a will. Sometimes people are taken back thinking, I thought we just needed a trust. Why are we doing a will? This type of a will is a special type of will that is used with these trusts, and it sort of works as a backup plan. If we have the trust, let's say the person forgets to transfer their home to the trust, this pour over will sort of pour over into the trust the assets that were left out. And also you will need to name a guardian. If you have kids under the age of 18, they would have to be named in a will, at least initially. Or if you have only one document, it better be listed on the will. The only problem, if you only use a will, is that wills only become effective when we pass away. So if parents become incapacitated, the will is not going to do anything. So in our office, we usually do the will, name the guardians in the will, and then we also do a separate document that discusses incapacity and who could be the guardian at that point. And then we do this temporary and permanent sort of guardian. And the reason we do this is that sometimes clients tell us that they want to have somebody that they really care for to be the guardian, parents, brother, sister, but this person lives far away. So now if something happens and both parents have passed away, if the guardians cannot get to the children, what will happen, the Child Protective Services will step in, they'll take the kids, they'll find temporary foster home for them. But in most cases, these temporary foster home, they don't take, 2 or 3 kids together. You have to separate them if they're, let's say, 2 or 3 kids. And you could just imagine what a disaster that would be. So the idea is that if we have somebody that it may take him a couple of days, a week, a month to kind of travel to where the guardian, the parents live, what will happen is that we want to appoint a temporary, so maybe a neighbor, maybe a good friend that is close by, so that person could step in, take care of the kids, inform the permanent guardians, and then that would be the planning for the guardianship. Scheduling your meeting with me, I'll tell you about our pricing. I'll give you a range of our pricing. We used to do hourly rates, but that sort of changed. Now we do flat fee just to kind of eliminate the surprise for you. And then it makes the communication easier. We could talk as long as possible. Before it was on the hour, clients would be very short answering questions. So the idea is to make sure we put the right planning in for you. Our planning, it ranges from $6,800 to $2,000. And it will really depend on what kind of planning we're doing for you. Are we just doing a will-based estate plan? Are we doing a trust for you? Are we doing a trust with the inheritance trust, the subtrust? Are we doing the marital trust, the credit shelter trust, the trust option at the time the first spouse passes away? So that's why the fee sort of ranges, and that's the difference between the 2,000 to 6,800. We can also help you with the what is it called? With the deeds that might be needed. If you have properties that you need help to transfer those properties into the trust, we have another company that helps us to get these things recorded, but the fee for the recording, to prepare them, to take them to the county, the notary fee, the filing fee, everything is $750 per deed. And then if you have real estate, not real estate, if you have an entity, a corporation, LLC, we could help you with those too, same sort of fee. And then if you schedule your call today, so what you would do if you're interested to schedule your call, you would type in the chat that you want to schedule your family planning meeting, and then my assistant would reach out to you, give you a call, and schedule this meeting with you. If you do it while we're on this webinar, I will go ahead and provide you with a $500 discount on the services that we end up doing. I will also waive the $295 consultation fee that I have. So that's about an $800 saving. I can only do this for the first 8 people that end up requesting to do this family meeting with me. So if you're interested, please make sure you put your information in there. And then in this meeting, we usually set up 2 separate meetings. The initial meeting, we'll send you a worksheet, you provide us with some information, and then in the initial meeting, we talk about what we're trying to do, what questions you have, what concerns you have, and how we could address all those things. And then the initial meeting, we could do in person in Woodland Hills, in our office there, or we could do Zoom or phone. And then the second meeting, which is usually about 3 or 4 weeks out, that meeting, it has to be in person. So you'll have to come to our office, or we have traveling notary because it's the time you're going to sign, and California doesn't allow us to do digital signatures for trust and will. So it would have to be in person. However, we have traveling notaries. We go to San Diego, Orange County, and then if you're up northern California, we have notary that we could arrange over there as well. My goal when I do these planning, I don't want you to think of me as an attorney that you work with one time and that's it. I want you to think of me as your family attorney, and because I want to make sure that we sort of keep in contact, I offer all my client a complimentary trust review every 3 years. I do not charge for the time I spent with you and your family. If we do need to make some changes, obviously there'll be a fee for that. But the idea is that we're doing the trust today. It's based on what you want. It's based on the laws that are in place now. But what's guaranteed in life is change. Sometimes it's what you want to happen within the trust, who's getting what percentage. Sometimes is the laws that are associated with this sort of planning. So again, the idea is that we touch base every 3 years. I ask all my clients to bring your kids if they're older, have them be at the meeting, have them be on Zoom, on the call, whatever it is, so they can get to know who we are. I can get to know them. And if unfortunately something happens to you, they know who to call. It's, usually it's a very tough time when kids have to deal with those sort of things. So that's what we offer. Let's secure your family's future together. And, I got a book. I forgot to tell you about my book. If you're wanting to get more information about estate planning, I wrote this book last year, Estate Planning for Real Estate Investors. You don't really have to be a real estate investor. If you have a real estate, I think it still would be a very good book, again, to get more information as far as basic
or we're looking, asset protection, LLCs, holding LLCs, irrevocable trust, a different type of irrevocable trust. They're all in here. You can purchase this book by going to Amazon or my website, talailaw.com. You'll see the book. You could click there and take you to a page that you could purchase the book. All right. So with that said, I am going to look to see if I can see some questions. It looks like there's some stuff here. And let's see what I can find. If you have questions that you want to ask, please make sure you put them in the chat, and so I could get a chance to answer them for you. If you're interested to make the meeting with me, please make sure you indicate that in the Q&A. It looks like a few people have already requested to be contacted. I could only do 8. Not a sales gimmick, just I don't have time. I only have so much time unless I could, clone myself and have somebody else. I'm the only attorney in the firm. I will personally meet with you and make sure the planning that we're doing is what you want to be done. All right, so let's see. Let's see if I can answer some questions. My assistant here, Helia, has put together some of the questions. Let's see. Which one is it? Okay, so the first question is it important to register or record the living trust with the recorder's office? Please, please, please do not record these trusts. Every once in a while, every 6 or 7 months, I have a client that they tell me they recorded the trust. I mean, the whole purpose of having the trust is it's for it to be private. So the trust should never be recorded. The only thing that usually sort of gets recorded where it would have the name of the trust is the deed. So if you have a property, the property you live in, or a real estate investment property, if we're doing a deed and the deed is transferring from your name to the name of the trust, obviously we have to write the name of the trust as the person, as the grantee. The grantor, the person who's granting, transferring the property would be you. The grantee, the person who is receiving the property, is the trust. So the name of the trust would be on the deed. The deed gets recorded, but that is the only thing that gets recorded from the trust. And it's really not the trust, it's just the name of it. So no, the trust does not have to be recorded. Obviously, you want to make sure you keep it somewhere safe, because yes, if it's not recorded and then all of a sudden the trust is lost, the attorney doesn't have it, then there are issues. So in our firm, what we do is we obviously, after doing the trust, we provide the client with the original documents. We scan all the documents. We keep a digital copy, and we set up the trust so that the digital copy is as if it's the original. And then we give the client the original document, and also we create a portal for them on our side. They'll get access to all the digital documents as well. And it's cloud-based, so if something happens, somebody breaks into the house, something gets lost, that those documents are still there, very safe. And so that's how we do it. All right, let me go back to the questions. From what I've learned, having a trust is a must to have if I own property, but a will is good enough if I only have money, cars. Yeah, that's correct. If you have real estate, again, so the problem with real estate, particularly if you only have one person on the real estate, if let's say it's husband and wife and the title is joint tenant, if something happens to the first spouse, in most cases, you don't have to go, the surviving spouse doesn't have to go to probate court because the deed sort of transfers to the surviving spouse. But, at some point, the surviving spouse is going to pass away. And now if he or she's the only person on the deed, you're going to have an issue, or the kids are going to have an issue getting the property transferred. They would have to go to probate. In most cases, the probate cases we have are heavily real estate. Heavily real estate. Probably 30-40% of the time, bank accounts that they just forgot to name anybody as the beneficiary of the account. So now there's issue with the bank account, and probably another 30-40% that the person has a corporation, they have a business, or they own properties in LLCs, or they have some sort of partnership and their interest is under their personal name. If you have an LLC, something happens to you, you pass away, nothing happens to the LLC. The LLC runs as, forever, as long as it has assets, as long as the business is functioning, it'll run. The problem is it's not so much that the LLC is running. The problem is the person who owned the shares or the membership has passed away. And those membership were under his name, her name personally. So in order to get him transfer, the only way we could do it is to go through probate. So that's why. Another question, how does the fee change per property I own? For example, I own 3 properties. If you're looking to do deeds, if there are 3 properties, the deeds are $750. If we're doing 3 deeds, we'll be able to provide a little bit of a discount, but these deeds are probably $150 of it just goes to the county for the recording fee in most cases. And then the fee to take it to the county, the notary fee to prepare them. We have very low profit margin on these things. So in most cases, the fee is just $750 times the number of property. If it's, let's say 3 or more, we probably could give you a little bit of a better deal, but nothing too crazy. I would like to schedule a meeting, Kathy. All right, we'll reach out to you. Does the book have all the form that we can create a trust? No, the book does not have the form. It's not really intended for you to take a look at that and make the trust. I would probably not suggest having you use a form to make a trust. Sometimes people use a will. That's probably a lot more simpler. So a will, if something happens and just hiring an attorney may just not make sense, then maybe a will be all right. But I see so many mistakes. We had a client that used an online service, paid a few $100 or whatever it was. They created this trust. Unfortunately, the parents had passed away, so they couldn't do anything. But kids were at the office. The trust, when they were putting the information in, the parents put their own name as the beneficiary of the trust. And then they had put the kids as the people that, the person that was creating the trust, their child. Everything was just placed back, was done incorrect. They had a trust. They paid, probably very little to get it. But we were in probate court for a long time, and there was a lot of fee that got paid through probate. So sometimes, you may save a little money up front, but do not think of it like that. Usually when you do these sort of planning, I ask my clients to put pricing like 3rd or 4th as far as your list of checking off, who I want to work with. All right, let's see. All right. Well, there's somebody talking about that they weren't able to participate entirely. I believe they maybe had to leave earlier. As I mentioned, we're going to have the recording emailed. So if you didn't get a chance to watch it, or if you want to watch it again to just kind of get more information, sometimes I may talk a little too fast, or these things, again, it's not stuff that we deal with all the time. So people have a hard time when we hear it for the first time. It just doesn't resonate right away in most cases. I'm trying to see if I know there's a lot of questions here. All right. One other question is, if I create a trust here in California and I have property in Arizona and Nevada, can this trust have the ability to hold these properties in there? And that's a really good question. And if you own properties in multiple states, having a trust becomes even more important, because if a person passes away, they have property in California, they have property in Nevada, they have property in Arizona. We had one, there were California, New York, Pennsylvania. But, it doesn't matter if it's outside of their other state. What we're really talking about now is doing probate in 3 different states. And you would have to have 3 different attorneys in most cases too. Again, like, we're only licensed in California. So now we would have to engage somebody in, whatever other states that are involved. And so I know you're getting what I'm saying here is that we're just talking about even more fees and even longer process. When you do a trust, it really doesn't matter if it's based on California law or any other state that the trust is created. As long as the property you own is within United States, it would be fine. So you could have a trust that we do here in California because you reside in California and you have properties in California and then you have properties elsewhere. It doesn't matter as long as the property has been transferred to the trust and it's owned under the trust name. The trust can manage and do the administration and distribute everything. The trustee would have power to sign the deed for a property in Nevada, for a property in Arizona, and obviously for a property in California. So there will be no issue. One more. If your property is under an LLC, but you do have a trustee that is a probate, you have a trustee that is a probate case. I'm not sure if I understand. If you have a property that you placed under an LLC, a lot of times I work with a lot of real estate investors and we're doing a lot of LLCs, holding LLCs. And again, it's mainly for asset protection. It may be for privacy or just kind of ease of dealing with tenants. A lot of times you don't want them to know where you live and that you are really the owner. So for whatever reason, if the property's under the LLC and you have a trust, you got to connect the LLC to the trust. The fact that you have the LLC and then you have a trust by itself here, the trust is not going to do anything. So what we do, we prepare 4 different set of documents: minutes and resolution, assignments, another minutes and resolution to transfer the membership interest, and a certificate. The idea is that we want to have a record from the company that says the company allowed you to transfer your shares, your membership interest to the trust. And then we get a new certificate from the corporation, from the LLC that says, for example, certificate number 2, X amount of shares are now owned by ABC Trust. That's really important. And so many times, so many clients I talk to that they don't know or they don't do it. So again, when you do these sort of estate planning, you want it to be comprehensive. You want somebody that takes care of all these little things. When unfortunately we're not here, in my practice, when I have clients that have parents have passed away, kids come to me, they are my clients now. We're spending a lot of time for these little things, and a lot of times it ends up going to court, and now we have the issues that usually is associated with going to court. I think I've answered. I'm going to try to go through the questions here, see if there's something that I'm missing. Ardev, the question is, if the property is under the LLC, then the grantors are becoming the trustee of the LLC. If the property is under the LLC and the LLC is owned by the trust, well, like if, let's say this is yours, you could be named as the manager of the LLC. So the trustee or the trust is really not involved in managing the LLC. So, the fact that the trust owns the LLC doesn't really make a whole lot of difference for the day-to-day activity. So you have an LLC, let's say you and your spouse are the manager of the LLC. We transfer your membership interest to the trust. You have tenants that come in there. It doesn't, as a manager, you could deal with them. It makes no difference. Are we becoming the trustee of the trust? In most cases, Arif, that sort of continuation question from him. Yes, parents, people that create the trust, they become the trustee of the trust. Trustee is the manager. So you're creating the trust, you're the grantor, you're the manager of the trust, the trustee of the trust, and you're also the beneficiary of the trust. As long as you're alive, you're the beneficiary of the trust. When we're not here, at that point, our kids become the beneficiary or whoever we've named as the beneficiary of the trust. All right, I think, learn from you without having interest in this. I hope this seminar or this webinar was helpful to you. Thanks for taking the time for being here. I think I've answered all the questions. I'm not sure how many people have requested, but if you're looking to sign up and meet with me, please make sure you indicate so we could get in touch with you in the question and answer. I'm gonna sort of end the seminar and then webinar in the next minute. So if you're still looking to set something up, please let us know. I'm not sure if we have 8 people or not. If we don't, I'm sorry, but if we do, then we'll set something up with you. All right. I think I've answered everything. Kathy, you're welcome. Catherine, you're welcome. All right. Thanks for being here. I appreciate your time. Again, if there's questions, please reach out to our office. Our phone number is 818-285-2850. It's in the emails and stuff that you've received. And have a great rest of the night. Out of the fee, the 6,800, that's usually like the trust and with all the sort of options in there. It does not include fee for the deeds that would need to be transferred. That's just the fee for the trust. So it just depends how we structure your trust. We may not need to structure it, with all the options in there. When we get to meet, we can sort of discuss and figure out what option would make most sense for you. All right. Thank you so much.